Welcome to Law Minstrel. I am Mwese Modupe Unyim. Today we'll be taking another important aspect of the contract of sale of goods. I'll be looking today at frustration. I'd like to pause and enjoin you to be a member of our community if you are not already one by simply clicking on the subscribe button, and you automatically be subscribed to our channel. I'd like to also enjoin you to give us a like if you enjoy our videos, and then share with your loved ones on any other platform that you find appropriate. You need to give us a feedback. Please do so by sending us a message in the comment section. Thank you very much. I said we're going to be looking at frustration in this episode. Now, we have already discussed mistake, of course, and we are now going to be looking at frustration. Frustration is a doctrine that is concerned with events occurring after the contract has been validly formed already. You will notice that in our video on mistake, we saw that mistake occurs at the time of the making of the contract. But in relation to frustration, is concerned with events that have occurred after the contract has been validly formed. So a mistake ordinarily would occur before a frustration. It's all right. So frustration deals with situations where performance becomes impossible or becomes illegal or is radically different from what the parties had anticipated ab initio. Unlike mistake, frustration occurs after the contract exists, not before the contract exists, but after it has already existed. So we'll look at the definition and the scope of frustration. Now, see, frustration is an unforeseen event outside the control of either of the parties, whether the buyer or whether the seller. This unforeseen event is completely outside their control, and this unforeseen event now makes the performance of the contract impossible or substantially different. Nigerian law recognizes frustration through the common law, supplemented by Section 2 as well as Section 6 of the Sale of Goods Act. You may do well to take a look at that. So frustration automatically would discharge the contract, unlike mistake, which makes or renders a contract void from the beginning. Frustration will simply do what? Discharge the contract. Now we'll look at types of frustrating events that may occasion a frustration of a contract of sale of goods. The first we'll be looking at is the destruction of the goods. And you know, of course, that goods are the subject matter of a contract of sale of goods. Section 6 sub 1 of the SGA. If specific goods perish without fault before risk passes, the contract is taken as having been discharged. And you see this on the authority of Taylor versus Cardwell. You find the citation supplied on your screen. In that case, destruction of a music hall frustrated the contract. We also look at another situation like an issue of illegality. Now, where it is illegality, where it now becomes an illegality to perform the contract, then subsequent law makes the performance to become illegal. That's the meaning. And you see this on the authority of Metropolitan Water Board versus Dick Kerr and Company. The citation is supplied. Now, in that case, the contract was discharged due to illegality. Now, we'll look at another incident in the event of incapacity or radical change of circumstances. You see, this may be where performance becomes impossible or performance becomes radically different from what was anticipated by the parties at the time of the making of the contract. Now, a good example is where import of goods become prohibited due to maybe government policy after the contract had already taken place. Then you see that the contract will become, the performance will become frustrated due to a radical change in government policy. So we now look generally at the effect of frustration, because frustration has effects on the contract. One of those effects is that contract is automatically discharged, and then parties are released from their contractual obligations under the contract. Then restitution may apply for benefits conferred before frustration. So if any of the parties already had benefits conferred on him and probably began to enjoy the benefits, he may need to restitute them to the other party. Let's do a distinction between mistake and frustration. What will help us to look to see clearly the difference between mistake and contract will be this table. So on this table, I've simply done a 3-column table with the following headings under each of the columns. You see feature, you see mistake, you see frustration. So what's the feature in the feature that differentiates mistake and frustration? One of those features is the timing. What time do they occur? What time does mistake occur and what time does frustration occur? In relation to timing, for mistake, it occurs before or at formation. Then frustration occurs after the formation of the contract. And we will now look at the feature of cause. What is it that causes mistake, or what is it that causes frustration? In this also there's a difference. What causes mistake is an erroneous belief, and what causes frustration is an unforeseen event outside control of either of the parties. Then we'll look at the effect of either of these issues, the effect of mistake and the effect of frustration. The effect of mistake is that it makes the contract void or voidable, and the effect of frustration is that it makes the contract automatically discharged. Okay, that's it. Then I'll just give an example and then we'll wrap up on that. So in the event of mistake, goods don't exist, seller doesn't own goods. But in the event of frustration, goods destroyed after contract, performance becomes illegal. Now, what are the comparative Commonwealth insights into the matter of frustration? In England, we've already given the case of Taylor versus Cardwell, and you also take a look at the Law Reform Frustrated Contract Act of 1943. And in Australia and Canada, you see frustration is recognized and restitution may also apply, just as in Nigeria. Now, Nigerian law applies similar principles, but statutory codification is limited. So courts normally rely heavily on common law doctrines. What's the policy take of frustration? Frustration normally protects parties from unjust enforcement when performance becomes impossible. Again, frustration encourages careful risk management and contractual drafting. So when you are drafting your contract, you take into consideration the matter of frustration. And finally, frustration will normally balance fairness and commercial certainty. We do a short recommendation for your further readings if you want to read more. So you could consult a Sale of Goods Act that is relevant in your jurisdiction. You could consult the cases that are earlier given, and citations were also given as well. So you consider such cases like Taylor versus Cardwell, Metropolitan Water Board versus Dicker and Company. Then you can as well look up Atia PS on the Sale of Goods, particularly the 12th edition. Thank you so much for being with us on this episode of frustration. If you did learn a thing or two, kindly give us a thumb up by way of encouragement, and let me hear your comments or feedback in the comment section. And please do well to share on your own platform. and then you are not a member of our community, please do not wait any longer. Kindly become one by simply munching on the subscribe button. Till next episode, I am Nwese Modupe. Thank you.